Good morning, everyone. Welcome to this webinar today. My name is Helena Solomou, and today I will be talking about the Third Parties Rights Against Insurers Act 2010. This session is recorded, and we will have time for a Q&A session at the end of the session. But if you have any questions, please post them in the Q&A box at the bottom of your screen, and my colleague and senior legal advisor, Harriet Strevens, will pick them up for us at the end. Where we do run out of time, we will deal with them all separately after this session by email. So the agenda for today is up on your screens, and we will come on to all of these topics. But the last time we addressed this Act was over 2 years ago, and today I will talk about what the Act is and how it works. But before we get going, here is a little bit of background to the history of the 2010 Act. So many of you will know that the 2010 Act was preceded by the 1930 Act, which previously allowed for a third-party claimant to bring a claim against an insurer where the insured was dissolved. However, there were a number of hurdles which had to be overcome before you could do so. The requirements were that a claimant had to overcome can be seen on your screen now. But this has all pretty much changed, and it is increasingly less relevant, having been taken over by the 2010 Act. The 2010 Act deals with liabilities incurred after the 1st of August 2016. However, it isn't retrospective, and insurers do need to be aware that claims brought before this date will still fall under the 1930 Act. So, why was the 2010 Act brought in, and what does it do? Essentially, the 2010 Act was brought in to streamline the process for third parties to make a claim against an insurer and against the insolvent insured, and to allow for the early disclosure of information surrounding insurance. So, how does the Act work? The parties can now bring proceedings directly against insurers without having to first establish the liability of the insured. In addition, a third-party claimant is no longer required to restore a dissolved company to the register once it has been struck off the register. On the screen, there is a diagram showing how the 2010 Act works. In essence, the insured is declared insolvent or is placed into administration and is the relevant person, which I will come on to later. Once this happens, a potential claimant can then effectively step into their shoes and claim directly from insurers or request information without the need to request an order or a declaration as to liability. So, who is the relevant person? Under Section 1 of the 2010 Act, the rights of the insured under the policy are transferred to the third party. The relevant person is an interesting phrase, and it is defined for both individuals and corporate entities. The relevant person does not necessarily only mean an insured that is an insolvent, but the Act defines a relevant person under Section 4 and Section 6. And some examples of when an insured can be a relevant person are up on the screen now. As you can see, it can include an individual or a legal entity, for example, a company. It can also include where the insured is in administration but not insolvent, for example, in voluntary arrangements. So the key features that insurers should be aware of is that the Act applies to insurance policies and not reinsurance policies. There is no contracting out of the Act, although there are a number of defences, which I will come on to. Furthermore, the liability of the insured to the third party, where that's greater than the liability of the insurer, for example, because of a deductible or because of an aggregation of policy limit, the third party cannot claim against the insurer for the larger amount. So, what if a claim is brought against insurers? There are a number of defences which can be deployed, and these are shown up on the screen now. As you would expect, the insurer can rely on all the defences it could have used against the insured, but of particular interest is where the insured has not notified or cooperated in accordance with the policy. These exclusions can particularly catch a third-party claimant out who initiates a claim prior to the insolvency. As the insured heads into insolvency, it is more likely that they will fall foul of their policy conditions, and insurers can rely on these breaches to deny the claim. However, if the insured is unable to fulfill policy terms due to their insolvency, for example, in relation to claims notification, the insurer cannot rely on the non-performance of the insolvent insured as a defence. So there is a differentiation between going into insolvency and once the insured is in fact insolvent. So in relation to the defences, there are a few cases to note, and I'll talk about the first two that are up on your screen now as an illustration. So in BAE Systems, there was an insolvency exclusion in the policy. The proceedings in this case concern the alleged defects in works carried out by the third defendant under a subcontract who then went into administration. The claimant sought to join the insurers as a direct defendant under the Act, but there was an exclusion clause which related to the relevant policy dispute, and insurers sought to argue that they could not be brought into the claim under the Act. It was found that whilst there was a defence, the Act was engaged, and so the claimant could issue proceedings and continue the claim. Once that was done, it was then for the insurers to present the defence. In the second case up there, in the third case up there, that is the county court judgment, and that was heard in August 22, and that's the case of Rashid and others. This case related to the alleged negligent installation of a cavity wall insulation. The judge found in this case that claims under the 2010 Act do not fall within the insolvency regime. So this meant that the general rule, namely that where a company goes into liquidation, time stops running for limitation purposes, does not apply. And so the usual limitation requirements applied. And that's one of the main differences with the 1930 Act, where under that Act, a claimant could suspend limitation from the date of the insolvent insured's liquidation. So the Act does not only allow for proceedings to be brought against insurers, it also makes it easier for third parties to obtain early information in relation to insurance from any third party who it reasonably believes might hold such information, for example, brokers. Previously, one of the main difficulties under the 1930 Act was that claimants could not obtain information about the insurance cover or even the identity of the insurer. But the position has changed under the 2010 Act, allowing for requests for information to be made to an insurer if a third party reasonably believes any third party might reasonably hold such information relating to cover and or insurance identity. But as with all of these opportunities, they do come with prerequisites. And the three limbs that the third party must reasonably believe are that the insured is in fact insolvent, which is fairly self-evident, that it has incurred a liability towards that party, and the existence of a policy which would respond to the claim. In these cases, the early provision of information allows for the third party to decide whether it is in their commercial interests to pursue a claim. There is a 28-day time limit, though, for insurers to respond to any such requests, and insurers should really try to adhere to this deadline, as if no response is provided, the third-party claimant can secure a court order for the information to be provided, and this can potentially result in unfavourable cost orders. So, although the request for information may place a large administrative burden on insurers, there are provisions to protect from fishing expeditions and extensive disclosure, and the relevant requests that a third party is limited to make can be seen up on the screen. So, what does the Act actually mean for insurers? The Act is triggered by the administration or the insolvency of the insured, and so it is increasingly relevant given last month the UK entered into a recession. Just for some figures for you, In 2023, there are around 25,000 registered company insolvencies, and this comprised of 20,000 CVLs. The number of insolvencies is actually the highest annual number since 1993, and some industries, such as construction and retail, are traditionally volatile, and it will be relevant across the professional indemnity and directors and officers spheres. So, generally speaking, the Act does have a positive effect for all. It is procedurally better for third parties and insurers. It provides an opportunity to scrutinise the initial claim against the insured rather than simply being presented with a judgment which must be paid. In addition, as an insured and not a party to the proceedings, insurers now have a greater control over the case and they can evoke defences in relation to causation and quantum without having to consider the needs and demands of the insured. For the third party, once the rights are transferred, the claimant third party can bring an action against the insurer without having to establish the relevant person or insolvent insured's liability. As such, the claimant third party only has to issue one set of proceedings against the insurer. The single set of proceedings and requests for information do, in fact, keep the costs down for all parties. So those are the takeaways, but do we have any questions?
We do indeed, Helena. Thank you very much. A couple of questions. The first of which is this. You talked about the information which a third party can request about the insurance position. And one of the items you mentioned that an insurer would have to provide was the terms of the insurance policy. What does that actually mean in practice?
Yes, thank you, Harriet. That is a good question. So the Act is actually somewhat vague in this area. Firstly, the insurer isn't required to disclose the actual policy documents, although it may choose to do so. But in respect of the requirement to provide details of the terms of the insurance policy, amongst the sort of other information that I've mentioned, it probably does require the insurer to give a reasonable amount of detail in relation to the cover provided by the policy, including any applicable insurance clauses, conditions, and exclusions. So, in effect, the third party will be entitled to receive sufficient information to allow them to evaluate the insurer's insurance rights that they've now acquired. So, insurers won't really be able to get away with being too limited in what they provide.
So that's a big sea change from the application of the 1930 Act, isn't it?
Yes.
A second question is to do with the very impressive statistics that you raised earlier on about the current rate of insolvencies. Is it your experience, as far as you're able to say, that this is leading to more claims being brought under the Act?
So while I can't really profess to be an expert and have conducted a sort of comprehensive study about the facts and figures, anecdotally, that does seem to be the case. As a firm, we are certainly more involved in claims, both sort of pre and post action, where the Act has been invoked because of the insured's insolvency. And we are hearing from our insurer clients that this is an issue which they are expecting to see crop up a lot more frequency. And I'd just say, sort of, given the number of distressed businesses, I do anticipate that this is a trend that will continue.
So would you say there are any differences between running a defence for a solvent insured and running a defence for an insurer under the Act?
Yes, there are quite a few. So to give some examples, firstly, if there are any cover issues, those potentially come to the foreground and can be part of the dispute between the insurer and claimant. Whereas with a solvent insured, the coverage issues and defence issues are generally dealt with separately, with the former being addressed behind the scenes between the insurer and the insured.
So arguably, insurers might take a more robust view.
Yes, definitely, especially on coverage arguments where they have them, because sort of any commercial relationship that they might have had with the insured will largely be negated by its insolvency.
So why would that be, would you say?
Um, they would that would be sort of with the claimant who obviously will be concerned by the risk that cover might not be applicable or available, and they might then be prepared to compromise on better terms rather than face the prospect of recovering nothing.
So presumably defending claims on the merits may be more complicated.
Yes, definitely, because getting the relevant information or access to documents can be harder when dealing with liquidators or an insolvent insured. But today really has been a very much overview of the Act, and we do offer training on the practical aspects of dealing with a claim under the Act. So if anybody would be more interested about that, please do feel free to get in touch.
Well, thank you very much, Helena. We're sort of pretty much at the end of our go, shall we say, for today. So I'll pass the baton back to you to close up, if I may. Thanks.
Great. Thank you so much, Harriet. I can see that we might have a few more questions, so I will do my best to respond to any questions by email. But otherwise, thank you so much for joining us today. Please do complete the feedback form, which will be on your screen once we sign off. Feel free in that to include any topics you'd like us to consider speaking about. And our next session will be on the 18th of April, where my colleague Arabella Hayward will talk about the fundamentals of fidelity insurance. I do hope that you'll be able to join us on that occasion, and I wish you all a good rest of the day. Thank you.